I request all the participants to join in as we are beginning up now. So let's start with it. So we are at our latest industry insight session, and the topic is new e-privacy regulation in connection with the GDPR. So we have our panelists joining in here, Dr. Ajai, Senior Director, Ministry of Electronic and Information Technology, Government of India. We have Beatriz, Ruiz, Beato. She's the EMEA Data Protection Officer, NEC Europe. We have Antonius Alexander Tigor, Head of Legal Business Partner, Digital Telkomsel, and the moderator for the session, Mr. Rajesh Kumar, Group Manager, Data Privacy Officer, Infosys. Over to you, Mr. Kumar.
Thank you. Thank you very much. So it's an excellent opportunity, and I would like to welcome all of you to this particular session. It's quite of an interesting journey in the last 3 years with GDPR coming into effect. So to just set the context on the topic, which is new e-privacy regulation in connection with the GDPR, which has its own pros and cons. And I would look forward to the esteemed panel members who are part of this session and provide their valuable insights. So just to give a context on this topic, so in keeping in pace with these evolving technologies, in 2012, the members from European nations adopted a major modernization process of data protection framework laws over the few years, which finally culminated in the adoption of the much awaited legislation called the General Data Protection Regulations. It is 3 years after the law came into effect. Till now, we have witnessed significant debate in this area, including 600 plus enforcements by several authorities within the Europe, and a radical change seen in other countries adopting similar framework of regulations, either by introducing new laws or amending the existing one, or totally repealing the existing laws in line with this particular framework. The same lines, the Commission also adopted a regulation called ePrivacy regulation proposal in 2017, and the report was adopted, giving the mandate for beginning of interinstitutional negotiations, which included some of the key areas. So, with taking this as an opportunity, I welcome all the panel speakers here, and I would like to have some series of questions probably which we can be debated, and I would also appreciate any additional points of view which the audience can benefit at the end of the day, the other speakers to also pitch in. So, Beatriz, hi, very good afternoon, good evening. So questions to you. I mean, can you just kind of provide what is the current status of this e-privacy regulation, and how do you see them very different from the earlier directive, which is still in force?
Thank you so much. Yeah, I can explain to you what is the current situation. After more than 4 years of negotiations, recall that they start drafting this regulation before the GDPR era. I do believe that the regulation on privacy and electronic communication appears to be at a turning point. And what I'm just saying this, it's because on February this year, the Council of the European Union announced that it has adopted a consolidated version, what it's called the Council position, and which will be the basis for trialogue negotiations within the European Parliament and the European Commission. Saying that, this draft already adopted follows the structure of the preceding drafts and includes a number of changes and reserves certain provisions that the German and the Portuguese Council presidency had delayed in their proposed draft, which caused that currently the Germany, and Austria abstained their votes on the Council's position. Also, I would like to highlight that the European Data Protection Board has already highlighted some concerns about this draft, but what is true is that the three of them are really prepared to negotiate the terms of the final text. So from my point of view, I think this year will be the year of the ePrivacy regulation with several concerns, but I think that they will be ready for launching. What are the main difference? I think that the first one is that it's a regulation and that it's clear. It's binding legal through each member states. It's not like the previous one, but it was a directive. And as you all are aware, the directive laid down certain results to each member states, yeah, and they are free to decide how to transpose directives into national laws. This draft creates a comprehensive set of rules for electronic communications, protect the privacy of end users, the confidentiality on their communications, and the integrity of their device. So unlikely the GDPR, it covers not only personal data, but also metadata, confidentiality requirements, and will apply to instant messaging apps, voice over internet protocol, platforms, machine-to-machine communications, and what we call IoT. So this is a big change with regards to the previously directive. Another thing that is changed, and also it's aligned with the GDPR, is that it's related to the scope. So it applies to users which are located in EU, regardless of whether the processing of their data takes place outside of Europe or the service provider is located in a non-European jurisdiction. So they are following up the GDPR extraterritorial scope. Another thing that it's different, it's the communication data. As a rule, the electronic communication data under ePrivacy regulation is confidential. So any interferences, including listening, monitoring, and processing of data by anyone other than the parties involved in the communication, is forbidden. In the last draft, they are inserting certain exceptions that permit processing that information without user consent. For instance, when it's because companies need to ensure the integrity of the telecommunication network, or to check any malware, yeah, or even to prevent threats to public security. Another thing that it's important to highlight today, it's the metadata. It's the first time that a European regulation defines what is metadata. It's not defined in the GDPR, but in the new draft, it's already. I think that it provides a clear definition of what it is. Also includes what is included under the definition of metadata, and it's important to understand telephone numbers, websites visited, geographical location of callers, website users shall be also included in the metadata definition. And the metadata, when we process personal data, metadata, and it's likely to result in a high risk for individuals. They are following up the same rules as the GDPR, and the data protection impact assessment will need to be completed. And if not, that should be go to the supervisory authorities in Europe. Of course, there are always exceptions, yeah, but this is one of the things that I would like to highlight. And another thing, it's the cookie, the nightmare of the cookie that most of the world are suffering. It's also regulated in this regulation. Of course, for processing personal data under cookies and any other technology, The position of this draft is that the users needs to provide the specific consent aligned with the GDPR requirements. And of course, all the users should have a genuine choice with respect to the use of cookies and similar technologies. Retention traffic is also highlighted in this regulation, but and they are mentioned preventive measures. We don't know exactly which are those preventive measures mean, and even worse, the retention directive it's already invalidated in Europe. So how are we going to follow up these rules or those requirements? Yeah, I'm just leaving it to open to you, but
It's quite
that's
interesting
my first
how
approach.
Sure. It'll be quite interesting to see how does e-privacy regulation interplay with GDPR regulation. So anyway, so my next question, probably Dr. Ajay, I would like to check a little bit moving towards much more on a generic topic, which I'm sure from an e-privacy regulations organizations would definitely be concerned. Is how does you see the democratization of personal data promotes innovation, and how does these data protection laws can assist these organizations?
Thank you, Rajesh. And once you have heard Beatriz talk about the GDPR and the e-privacy regulations in Europe, so let's understand where the world is moving. At one perspective, data becomes the central enabler for trade and economics to flow um, in the world. And there is some sort of a huge monopolization of products or platforms that actually have the capability to monopolize these. So you are talking about a huge number of proprietary digital platforms, and that every country is concerned about. At the same time, the privacy has now moved from the physical to the electronic world. What it means? It means that because privacy is cultural dependent, and whereas the IP laws are harmonized according to the TRIPS, there is no set of harmonization rules that actually controls the data flows or the data or monetization of data that is there, and that is a thing that is of concern right now. Every set of countries, Europe coming with GDPR, India in the process of legislating a data protection act of its own, Indonesia coming with a different act, US has US it's a little more complicated with federal laws, California bill, the New York bill, and so there is a whole set of different rules uh, that control the data flows or exchange of data or data being monetized or data being used. So my point is that how do you actually play in this world where at one place there are proprietary digital platforms, and the second there is a separate set of laws that flows across different geographies or different set. So it complex the situation. In India, what we have done is something very different. We came up with a concept of public digital platforms. The unique identity or a biometric identity that every citizen in this country has. The way the payment wallets have been actually integrated with the financial ecosystem through a unified payment interface called the BHIM, the health stack that we are developing, and another 16 set of public digital platforms. What it does is make common digital layer, and everyone is allowed to use the data under a set of rules that will be actually controlled by legislative processes, and which I think the Data Protection Act of India will be important. The data which is anonymized is available for all to innovate and create new businesses and new opportunities. It doesn't become a property of one major player or one large player or one basic player, and that creates the whole stifling of actually the concept of an open innovation network. That is, I think, is a possibility and a real fact. And in the post-COVID world, it has become a lot more important that how do you create a faster pace of innovation? Tell me, a vaccine coming out in 10 months, would it have been possible without an open innovation ecosystem? Never. Huh? So the point, Rajesh, what I'm trying to flow is that today, the world is moving from closed monopolistic IPs to IPs that enable an open innovation networks, a limited set of uh, monopolies that you get out of an IP control, and a many more an opportunity to partner or collaborate with others to create an innovation which is faster at a pace which enables things to happen at a much faster pace than that happened earlier. And this is what I am trying to drive through what I call as democratization of data, an important enabler of open innovation, and the IP law or the privacy laws enabling that. The e-privacy bill that Europe is talking about, or the regulations riding over the GDPR, is actually a step in that direction, and I am happy to share that. Thank you.
So this is a great insight. So specifically, data as an enabler. It's been a long time that most of the sessions you listen, you hear the word as data as the new oil, data as the new currency. I think data as an enabler is quite an interesting phenomenon. Thank you very much, Dr. Ajay, on that. So, Anton, just taking this discussion a little bit, and I'm sure from an e-privacy regulations, one of the major sector that will have a huge, focus would be the telecommunication sector. So, your thoughts and insights on that?
Well, thank you very much, Rajesh, for your question. In regards to the telecommunication industry, it's quite unique because telecommunication industry is one of the business sector that have an impact from the e-privacy regulations. And we know that there is some comment from the proposal regarding the e-privacy regulations. The telecommunications companies are sure to be scrutinizing the next stages of the negotiation to assess the evolution of the legislation and what it means from them. So the particular areas of interest, some relevant areas of interest for telecommunications companies are likely first, like the direct marketing. There is a little substantive change here. Although the member states in Europe are entitled to provide a specific period of time after which direct marketing consents will expire, or assigns call identification prefix to identify direct marketing calls, and also the metadata that Beatriz already mentioned in the previous uh, metadata. The draft allows for processing of metadata without consent for certain defined purposes, like for the national security and so on and so on. These relate to information security, fraud prevention, service provision, for example, billing and managing abuse of the service, or for the protection of vital interests, which follow the same concept used in the GDPR. And the other thing that we can look is about the retention and surveillance. The draft provides for an exception from the requirement to obtain consent and to delete or anonymize device data and metadata once it's no longer needed to provide the service, where this is required under the UN or member states law for the prevention, investigation, detection, or prosecutions of criminal offense, or prevention of threats to public security, like terrorism. Whilst provision for use of data for these purposes was included in the previous draft, the new draft clarifies that the data can specifically be retained for these purposes. And the reproposing of data in line with the proposed limitation principle set out in the GDPR, because one of the GDPR principles is the data limitation, and the pseudonymized metadata and device information can be processed for purposes other than those for which it was collected, provided such processes are compatible with the original purpose, based on the fairly loose defined criteria. This introduced some uncertainty, however, over such data will be used over time, particularly taking into account developments in technology, because it's so fast. While this provision will be good news for telecommunications companies, honestly, there are still some limitations, like data originally for processed on the basis of consent or public interest cannot be repurposed in this way. The data cannot be shared with third parties other than the processor acting on the service provider behalf. So that's some insight from me, Rajesh.
Thanks, Anton. It's a lot of info to digest. I mean, it's as Beatriz was mentioning about in terms of cookies, the metadata, the communications, and with the new players such as the OTT or the VoIP and all those people playing, and I think telecom industry will play a huge trajectory role. And so how do you see? I mean, Anton, the question is to you. How do you see the trajectory of user privacy will be defined very well within to meet this? I mean, as users, typically the surveillance being one of the key concerns among users, and specifically, and that's the ask in the name of national interest by countries. How do you see that's getting balanced between the?
Great, interesting question, Rajesh. So for sure, for the customer, it will be very good for them because it increase their rights for their data, and they have the several access, the new rights for the customer. It's really important for them, and the use and the protection of the customer data, the rapid development of the regulation of data and online security, which has accompanied or sometimes trialed technological development over the last few decades, is increasingly affecting telcos, posing growing challenge for their businesses and customer relationships. And for the telco, data is both of key assets and key risks as well. The telecom business is increasingly data rich because a lot of the communications, like the name, MSS, the MSSI is the end, the telephone numbers, and a lot of information from the telecommunication service. And the tools available to exploit user data are developing rapidly. User data is a valuable resource both for telcos and for a wide range of the potential partners looking for the provide value-added services like data analytics and other services that they can exploit the data. These opportunities need to be assessed against a constantly evolving regulatory background. As countries across the world introduce new data privacy laws, not only in the EU, but also in others part of the world, like in Asia or in Africa, in US, and it's always evolving, and there is always a new because the technology development is always new, uh, and the cybersecurity always is a legal issue wherever it's happened, right? Cybersecurity is a critical issue for the telecom sectors. Networks are vulnerable to cyber attacks from criminals and terrorists, activists, hostile government and insiders. For network operator, this may appear to be primarily a technical issue, but the legal and regulatory consequences are equally important. Understanding the legal framework um, that sets the standards, that notification requirement, and the benefit of expert privileged legal advice. It's so vital to managing the cybersecurity incidents. And again, it's back again to privacy versus retentions. Telcos are coached between user desire for privacy and increasing regulatory demands for retention and access to data. Absent a global consensus on cybersecurity issues, one country level demand for access to data for national security purpose, maybe it's different from another country for cybersecurity incident, and its impact to the jurisdiction and the regulatory, because once we talk about the data, the privacy, and the cybersecurity issues, it is cross jurisdictions issues as well. So it's very important that we knows and understands what the other jurisdictions uh, about. That's what I'm thinking, Rajesh.
It's a valuable insight. I mean, definitely, because it's a cross jurisdictional issue, and it's something which is not easy to comprehend when requirements arises. So, Beatriz, I just wanted to jump off. I know we are listening more on telecom, but there's one more particular sector or industry which has a huge kind of an impact, which is the cloud service providers. Because we are all talking about data, you need to keep the data, and the much scalable option to keep and store the data with all these principles from either from GDPR and ePrivacy that impacts us more. It's on the cloud service providers. So can you just give some valuable insights in terms of how do you see the ePrivacy regulations can change the way how this cloud service providers can get impacted around?
I mean, I'm not only service providers, because service providers can be, yeah, under the definition of the ePrivacy regulation, can be several companies. But what is clear is that under the current directive, does not apply to electronic communication services offered by providers that they operate over inside the fact that they offer services, which is functionality equivalent. So that's going, I'm including myself, I'm an IT provider company. So there's not going to be any difference. And I think that the main question is,
Great. Okay. Just doing a little bit of a time check. We have another 5 more minutes, but I have one question for Dr. Ajay. This is something, since we are talking about the future, that is the e-privacy regulations, the data protection laws, and we were talking about telecom industry as well. So, Dr. Ajay, with respect to the 5G evolution, how do you see these new regulations such as e-privacy, GDPR, will have impact on organizations? Any potential challenges that you portray or foresee, and what organizations may face?
Thank you, Rajesh. A very interesting question. So let's understand the 5G is going to revolutionize the way telecom works, and it moves the telecom from the hardware to the software. It moves the telecom from from a standalone infrastructure to a cloud infrastructure. And if we understand that all this is a borderless concept, and the privacy regimes have geographical boundaries, the complications it creates when a same set of players actually provides services to multiple geographies, leading to catering to different sets of e-privacy regulations and laws, is one set of complications that one has to deal with. You have to have a completely different Management infrastructure, when you talk about managing data in Europe under the GDPR, and that's a whole lot of challenge. I think manage will be well aware of that. How do companies manage GDPR in their geographies? And you from the Infosys, I know the type of uh, so it increases the whereas it increases the cost, but it increases a set of restrictions. And if we come to actually accumulating the whole set of restrictions, then are we stifling innovation, or are we creating a new set of innovation, or are we giving a better quality of control to the consumer is what we are actually concerned about. The point that I want to drive is that there has to be some set of international rulemaking that has to go behind it at a very, very quick pace to actually enable the world to take the benefits of the 5G experience that is ready to be provided to the world. There is one set of other very important set is I will talk about is the trusted networks. In the till the 4G uh, uh, systems, when actually it was not on a cloud or it was not on a central localization, security and privacy connotations were within the national regulations. And the national regulations in most of the democratic countries provided opportunities for the state to be segregated from the provider, service provider. And that was a very important concept that actually allowed the confidence of a telecom service provider and as well as the consumer that he is not being regulated or monitored on a telecom network. In a 5G space, where where certain countries having a considerable stake in provisioning 5G services have a very different connotation to privacy of individuals and to privacy of and to ethics of in that regard can have a very different set of different set of complications in the 5G space, and there can be rules which go beyond having regulations to having actually control over the type of service provider or the equipment providers that can be there in the 5G space. And that is a new set of complications that is actually evolving in the 5G space. And that's, thank you.
Interesting. I mean, interesting. I mean, ethics is one of the key. And I think that's going to be much of the future debates. Just on the time check, I think we have almost come. I would like to starting with Beatriz. Uh, all any one pointer that you would like to just press on a short basis for the audience on this particular topic.
This regulation will be protected individuals, but as I really mentioned previously, will complicated business models, infrastructures, and moreover, as we are in this digital transformation global environment, will be very, very difficult to implement.
Really scary.
I'm criticizing this law.
The scary one. And definitely not somebody who working in an organization would love to really hear it. Dr. Ajay, from your side, any one single pointer that you would like to share for the audience?
If you take from the India's perspective, privacy is part of our fundamental rights and part of the basic chapter on of the our constitution, and which the Supreme Court has also said. It's a whole new set of challenge in the e-world, in the evolving world, data world, that how do you actually respect this privacy regime when you talk about a borderless world, when you have actually little control on the way the data is being handled by private entities, and at the same time you allow business opportunities to flow and to grow. There will be increasing concerns of privacy of citizens that will be coming, and how the world creates a balance is a new set of new normal that will be evolving in the coming years, and it will be the most debated subject, I think, for the next few years.
Thanks. Great insights and also a side of comfort that the profession of privacy professionals, the jobs are in stake. So no AI is going to take over that. So that's great to hear. Antonio, back to you. Your thoughts in a single liner, which you would like to give it to the audience on this topic.
Yeah, I think we have to make it keep balance between the privacy and then the digital transformation, the opportunity of, and then the benefit of the digital in this digital era. In some perspective, I'm very happy because I'm also the users of the service providers, so I'm protected by the law. But on the other hand, it's also a great challenge as well as a good for me because it's open to many opportunities for the job, for the certain skills. So I'm happy to to support and still have a critical thinking to gain the big benefit of the digital era.
Sure. I totally concur with your thoughts. So anyway, since we have almost passed the timeline, I would like to take this opportunity to thank, Beatriz, Dr. Ajai, Garg, Anton, for the great insights. However, I would like to take this opportunity Beatriz, Dr. Ajai Garg, and Anton for this valuable insights. It was a great opportunity to have this debate with you and moderate this session. And once again, I would like to thank all the panel speakers here. And thanks also to IPR Gorilla for having me here and for giving me this incredible opportunity. Thank you. Thank you very much.
Likewise, Rajesh, and good to have you and moderating this wonderful session. And in the meanwhile, if anyone would like to drop in question, they can write down on the chat box on the right, or they can join face to face with the speaker and ask them directly. So thank you, Dr. Garg, Mr. Kumar, Anton, and Beatriz.
Thank you.
Thank you.
Thank you.
Thank you.
Bye.
Thanks.
Bye.
Everyone.
Bye.